I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. The problem that you have is because you have so many prior theft convictions, every time if you still steal a pack of gum, it's a felony the rest of your life. They call it 26CR106, State of Texas versus Eric Jason Verroy, who is present with his attorney, Mr. Dusler, and the state's attorney. Does the defendant waive a formal reading of this indictment and the arraignment here? And we proceed in summary.
Yes.
In summary, this indictment alleges, looks like there's 3 paragraphs here. An allegation of the crime of burglary of a building, and then 2 prior convictions of burglary and a second conviction of assault on a public servant committed in Jefferson County. The burglary, you were convicted in 2008 in the court next door, the 252nd District Court. After that was final, it is alleged you committed the felony of assault on a public servant. You were convicted of that in the 102nd District Court of Bowie County. It's a ways off in 2023. So paragraphs 1, 2, and 3 constitute a state jail felony, but it is punished as though it were a second-degree felony because of the prior felony. So you understand how that works. All right, so in summary, again, the state's on or about May 5th, 2026 in Jefferson County, Texas, you committed the crime of with intent to commit theft. You intentionally and knowingly concealed yourself in a building and committed burglary of a building of the Civic Center here in Beaumont. Paragraph 2 goes on to allege that on February 6, 2008, in the 252nd Judicial District of Jefferson County, Texas, next door here, you were convicted of burglary of a habitation. After that burglary of a habitation conviction was final, it is alleged that on or about May 5th, 2023, which would have been 15 years later, you committed the felony of assault on a public servant, a 3rd-degree felony, and that was a conviction in the 102nd District Court of Bowie County, Texas. So again, paragraphs 1 and 2 and 3 constitute a state jail felony, though punished as though it were a second-degree felony. Do you understand how that all works?
This one. I do 40. It's higher. I think it's fair. You have confetti.
All right, this means that you are facing a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment range you would face?
It's sort of. Right.
An agreement has been reached where you would be pleading guilty, sentenced to 5 years in prison. Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this indictment in paragraph 1, charging you with the state jail felony of burglary, guilty or not guilty?
I'm guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
And these 2 prior convictions, burglary of a habitation and assault on a public servant, as we discussed in paragraphs 2 and 3, are those allegations true and correct as they are alleged?
Yes, sir.
And are you pleading true and correct to those allegations voluntarily and because they are true?
Yes, sir.
I show you what's marked as State's Exhibit 1. Did you sign that? Understand? Discuss it with your attorney. Are the contents all true and correct? State's Exhibit 1 tendered into evidence.
No objection.
Without objection, it's admitted. Among other things, this stage you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses, and you are giving up your rights to a jury trial, the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1 is part of the record for all purposes. Is a pre-sentence report waived?
Yes.
I'm going to follow this agreement. If nothing further to add, I'm going to find that you are pleading guilty and true to paragraphs 1, 2, and 3 respectively, which constitutes a state jail felony, burglary of a building, though punished as though it were a second-degree felony by the consecutive sentences and convictions in time, paragraphs 2 and 3. You are mentally competent to enter these pleas. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this state jail felony, punished though as though it were a second-degree felony because of the prior felony convictions. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. And of course, you will be given credit for all time you have served in accordance with this case. You understand what has happened today, sir?
Yes, sir.
Anything else? Okay, that is fine. Thank you. 26 CR 1119 is called Daryl Wayne Cooper. You're Mr. Cooper?
Yeah.
Is that right?
No.
All right, we've got two problems here you probably are intimately familiar with. There's a theft of property, and it's not a lot. It was at
Household judge.
It was food from Walmart.
Walmart, but the problem you have, I mean, looks like it was about $10.
I think that's.
The problem that you have is because you have so many prior theft convictions, every time if you steal a pack of gum, it's a thing the rest of your life because you have so many convictions. That's the way the law works. Is prior convictions mean people who commit another crime thereafter are held more responsible than people who have not had a criminal history, generally. So my advice, of course, is don't steal. Because every time you steal, it's a felony at the minimum. So that means you're looking at no less than 180 days up to 2 years in the state jail. And a fine up to $10,000 can be assessed. Do you have anything about his probation that you can transform me?
We have the motion that was filed yesterday, Judge.
Oh, great. Okay, let me look at that.
It's not,
You're also on probation for another offense. And a motion to revoke probation was filed probably because of this theft here in this new case. So you've got two fires you've got to deal with. And you know that. Mr. Deucer's good man. He can help you navigate through this, but you're going to be held accountable. And because you have a felony, it looks like there's a felony in this court in 2010. So you're not eligible for probation anytime you commit a crime in front of a jury. Jury cannot give you probation. So
right?
in this other case, yeah, a motion was filed this morning to revoke your probation, and this was criminal mischief. You were placed on 5 years deferred or unadjudicated probation back in August of 24. So 2 years ago. And this motion alleges that You violated your probation by committing theft, which is represented in this new indictment, committing the offense of criminal trespass on or about May 1st of this year, failing to report to the probation office on or about May 5th. How long have you been in jail? A while? When was he put in jail?
I'm gonna say May 1st with this new theft. Was he arrested?
Was he caught in an act?
Yes.
It's going to be hard to report.
June 13th,
I'm sorry?
June the 13th.
Okay.
He was placed in custody.
So he was still free.
Gotcha.
He failed to report on May 5th. That was before his arrest. He's in arrears of restitution in this criminal mischief case of about $3,400,
That was the original.
which means, looks like he hadn't paid anything on the restitution since he's been placed on probation for 2 years. But you're stealing. You're committing crimes, but you're not paying what's due. So there are 5 different grounds here of violations of probation. And this is a state jail felony that you were on probation for. So you were looking at up to 2 years in the state jail. And this new case also carries with it a punishment range of up to 2 years in the state jail if found guilty. So that's 4 years in the state jail, and there's not much parole on the state jail. You've got to serve almost all of it. So that's a lot of time. So Mr. Dusler is going to have to work with you to see if there's something that can be figured out.
And now the judge puts the brakes on the final sentence. Even though the guilty plea has been accepted and the court has found sufficient evidence, sentencing is being delayed for a pre-sentence investigation report, or PSI. That report gives the court more information about the defendant before deciding the final outcome. So this isn't the ending, it's the setup for the next decision. The big question is, what will that report reveal, and could it change how the judge handles this case?